Okay, we'll go to the second matter, and this is Murphy Rigging and Erecting, Inc. versus the Virgin Islands Water and Power Authority, and this is number 54 of 2021. Attorney Bence.
Good morning, Your Honors. Karen Bence on behalf of the appellant Murphy Rigging. I'd like to reserve 3 minutes for rebuttal.
Very well.
Your Honors, the issue of whether Title 30, Section 111A of the Virgin Islands Code violates the contract clause of the United States Constitution is a case of first impression for this court. Prior courts interpreting the Virgin Islands law on this issue only dealt with the issue of attorney's fees and costs in the context of a contract case involving VIWAPA. That was the Gardner case involving Judge Brotman. And the tort cases where VIWAPA was allegedly a tortfeasor and in personal injury cases. In those cases, the various decisions held that the injured party had access to insurance proceeds and therefore was not without a remedy. This statute, as enacted as part of the VIWAPA enabling legislation, was interpreted by the Superior Court to completely eliminate and abrogate the ability of Murphy Rigging to collect on its judgment under the Uniform Reciprocal Enforcement of Judgments Act. VIWAPA contracted directly with Murphy in Minnesota, agreed to pay storage charges to them, which they then defaulted on, including allowing a default judgment to be entered against VIWAPA in Minnesota. Now they're claiming under this statute that they are completely immune from execution on the judgment, thus making Murphy's contract completely worthless. There are 3 main points I'd like to make this, Your Honor, that may not have been in the briefs. First of all, Title 30, Section 111A of the Virgin Islands Code violates the Contracts Clause of the Constitution. Secondly, even if Section 111A does not violate the Contracts Clause, the Superior Court erred in denying Murphy's writ of execution as it failed to distinguish between the claims for breach of contract and claims for tort. And the public policies on those 2 issues are very different. And thirdly, Murphy is not seeking a judgment against VIWAPA's assets, but rather release of monies that it's rightfully belong to Murphy, but which are being withheld by VIWAPA. First of all, the U.S. Supreme Court has repeatedly held that the states cannot adopt policies that deny parties the means of enforcing their contracts. So the Supreme Court is
let me ask you, you said these were 3 things that you didn't raise in your brief?
No, I raised this, but there was a few cases I want to raise.
Okay. But before we get into that, let me ask you, how was this petition filed in the Superior Court? Who filed it?
The petition to execute, I filed it.
No, to domesticate it, the judgment.
I believe it was filed by Murphy directly.
Okay. And is he a lawyer?
The client is not a lawyer, no.
And the client is a corporation?
Yes, Your Honor.
And can a corporation file suit in its own name without representation?
No, and I believe there's a footnote from Judge Dunstan to that regard.
So then how could it be acted upon if it was improperly, if it was filed by a non-lawyer in violation of the unauthorized practice and the rules of this court?
I don't believe it was, Your Honor, when I discussed it with, I believe when I read back through the opinion that it was filed by Murphy itself. It may have been transmitted by their counsel in Minnesota.
Yeah, but I understand it was transmitted to the clerk by counsel who was not a member of the bar, but it was filed by a lay person on behalf of a corporation. Is that allowed anywhere?
Not in our statutes, Your Honor. I believe a corporation has to be represented by counsel.
Okay, and since that wasn't the case here, should we even be considering this?
I believe that you should, Your Honor, because they still are, they did hire counsel, that's me, and they have a right to attempt.
But they didn't hire counsel to bring this petition to domesticate it in court. So why should we even be considering an illegally filed petition that started this process?
Well, I don't believe that that was a holding of the Superior Court, Your Honor. I mean, that's for you to decide. It's not before this court. It wasn't in the briefs.
It's not before the court?
Well, it wasn't argued in the briefs, Your Honor.
So should this court be aware of an unauthorized practice of law and condone it by going ahead and rendering relief, as apparently the Superior Court did?
If Your Honors feel that was the case, then I think you can do what you need to do.
Okay.
I will state that they were cautioned.
There was what?
I will state that they were cautioned, that after I got involved, I said, we have very serious rules about that here. So I don't know what else I could have done, Your Honor.
Well, I'm not sure that I understood what you just said, Attorney Benz. Your answer was?
My answer is, Your Honor, whenever I get calls or get involved in these things, I tell them that there are very serious rules about the unauthorized practice of law in the Virgin Islands. And that's a standard thing that I state to people. And they hired counsel. It's actually a very large law firm in Minnesota.
But it was no member of that firm was admitted pro hac vici in this case to represent. And apparently they feel like just by sending it to the clerk and say, please file this on behalf of this corporation.
I can't get into the mind of what was going on there, Your Honor. The facts are that it was filed pro se by the corporation. I don't know any rule that would prohibit a company from filing its own judgment.
You don't? Do you know any rule at all that allows a corporation, other than maybe if there are special rules for small claims where you can't have an attorney, to actually commence an action in court, or for anyone other than a lawyer to represent the corporation in court?
No, there isn't. But if you're simply filing a judgment, I mean, I'm not sure exactly, Your Honor. I'm actually not really prepared to discuss this issue now, nor I don't. So.
But just to be clear, you recognized it when you became involved with the representation, and nevertheless proceeded.
I read Judge Dunstan's opinion and his footnote, and I got involved after the fact. I had the record before me. Whatever was there was there. I guess all I could have done is refile it.
All right.
So regarding your constitutional claims, why should we consider them if you did not, since you did not raise them before the Superior Court?
Your Honor, because the VI rules of appellate procedure allow this court to do so under VI rule of appellate procedure 4H, and also on the principle of manifest injustice. I mean, if this is not the time to raise a constitutional claim, when could one be raised? It has to be raised at this point, and the court can consider it because manifest injustice will result.
Let me ask my question a little differently. Why did you not raise it before the Superior Court? Why did you not raise those issues before the Superior Court?
Your Honor, I did not see that issue until I started researching for the appeal. We were responding to an opposition to a motion to quash, and I didn't see it. So that's the honest answer. But when I started researching these types of cases and the court's opinion, I realized that the court had failed to distinguish between tort and contract, thereby leading me to the issue of whether or not this statute abrogated their contract. And then I started looking at the Supreme Court rules or cases that state that, you know, you can't, a municipality or a state cannot contract away their debt obligations. It's, you know, basically in the case of U.S. Trust versus New York and New Jersey, the court stated if a state could reduce its financial obligations whenever it wanted to spend money for what it regarded as an important public purpose, the contracts clause would provide absolutely no protection at all. Thus, a state cannot refuse to meet its legitimate financial obligations simply because it would prefer to spend the money to promote the public good rather than private welfare of its creditors. You have to keep in mind, Your Honor, in this matter, Murphy, this is different than a tort case. Murphy was contracted by VIWAPA to store this equipment. It's a contract case where the money should have been budgeted to pay this. This is not a tort where an unexpected, unintended consequence happened where you have maybe Attorney Holt getting a $4 million judgment against VIWAPA and he could execute on it. This is different. And the Superior Court failed to distinguish between the two.
If this provision was in the contract itself that your client signed, would it have prevented you from collecting?
You mean if there was notice of this provision?
If there was a provision in the contract, you know, if VIWAPA included this language in every contract it entered into, including yours, would it be binding on you, on your client?
It might be, Your Honor, but they did include in their, if you look at the appendix, at Joint Appendix 75, it clearly states that they waived sovereign immunity, leading Murphy to think that it was collectible because they, you know, at the time.
Yeah,
so,
yeah, this is failed. The other one, I think
it was clearly waived. I hear somebody else.
Yeah, Attorney Handy, will you mute your mic, please? Isn't it everybody's obligation to know the law? And that if this is a law that's been on the books for 40 years or however long.
It's in our brief, Your Honor, through the Revised Organic Act.
Okay, but you point to me the section that adopt that?
Are you saying it's not? It doesn't apply?
Well, I mean, how does it apply? You know,
so,
section 3 doesn't adopt section 10 of the it adopts section 9. So how does it apply to the Virgin Islands?
Your Honor, that is addressed in our brief. The contracts clause does apply to the Virgin Islands under the.
But tell me how. I don't, because it's in your brief. I want you to explain to me how does it apply. If it was not made applicable through the Organic Act, what made it applicable?
Also, the Title 30, the full faith and credit clause of the United States Constitution and Section 3 of the Revised Organic Act.
Okay, so tell me which section of the 3 that says that the contract clause applies. Because when I looked at it, it says Article 4, Section 9, and it does not include Section 10.
I'm sorry, Your Honor, I've got something on my screen that just popped up. Sorry.
Okay, well, you can think about that while you.
I will.
Yeah,
I'm going to find it in here.
I think, Gregory, you can proceed.
May it please the court, Attorney Aisha Gregory. May it please the court, Attorney Aisha Gregory, on behalf of the Virgin Islands Water and Power Authority. It is well established that the Virgin Islands Legislature has the authority through its police power to enact laws that regulate the health, safety, and general welfare of the people of the Virgin Islands. Title 30, Section 111A falls squarely within the legislature's police power as it protects the assets of WIWAPA, the sole utility on island, from levy, sale, execution, or any other judicial process. At the outset, the constitutional arguments not raised by Murphy before the lower court have been waived in accordance with this court's decision in Benjamin VIG. Even if the court were to consider such arguments, we know that the Superior Court did not err in its interpretation of Section 111A, because when a statute's language is plain and unambiguous, no further inquiry is required by the court. Without question, Section 111A withstands this inquiry. And while Murphy argues that Section 111 violates the contract clause, we know that the U.S. Supreme Court has explained the contract clause should not be read with literal exactness. Its prohibition must be accommodated to the inherent police power of the state to safeguard the vital interests of the people. More importantly, the long-standing principle of public property exemption from judicial process has been codified several times by the Virgin Islands legislature. A judicial process exemption applies to WIWAPA, waste management, UVI, and the Port Authority. This demonstrates a clear intent by the legislature to protect the assets of public corporations for the benefit of the people. As such, the lower court's decision to quash a writ of execution against the assets of WIWAPA must be upheld as a matter of law. And to answer your question that was raised previously, unauthorized practice of law is not permissible in the Virgin Islands, according to 4 VIC 443.
Okay. You never raised that issue anywhere before, right?
No, I did not. No, I did not, Your Honor.
How about the waiver? Do you agree
I
that?
did.
So what is your position on whether or not we should consider these arguments, constitutional arguments that were not made below?
Right. None of the constitutional arguments should be considered. I cited to Benjamin VIG, but also the fact that there are no exceptional circumstances here that would warrant the court's consideration of the arguments that were not waived. Essentially, the arguments before the lower court could have been argued in the response. So WIWAPA filed its motion to quash, but there was a response filed by the other side which could have raised the constitutional issues, and they were not raised. And so therefore they have to be waived. And this court even explained in Simpson, the point is to have a full record with all the facts, all of the law considered. Even the argument concerning the difference between contract and tort was raised in the lower court. Why not raise constitutional issues? They should have been presented.
Okay, if we get to the constitutional arguments, or even if the contract clause doesn't directly apply to the Virgin Islands, you would agree that the Organic Act has the same language, just about, right? So,
yes.
Now, Council made a big distinction between tort actions and all of the cases that have decided and upheld, Section 111A, have done it in the tort context, correct?
Correct.
Has it ever dealt with it in a contract situation?
Not to my knowledge, no. There is an early case from the municipal court in 1959. It's actually Kuchar v. Hewer, but it was a cursory discussion and it wasn't enough to raise as a contract issue. Essentially, in that case, sorry?
But you understand that there is a big difference between tort actions and contract actions. And that Section 2 gives absolute immunity to the government, correct? Which yes. It could waive it as it did. And then waiving it, it can not waive it, it can waive it with limitations, so that a court ruling that a tort action, the legislature would have the authority to put limitations on the execution. But the same section provides that that the government of the Virgin Islands can sue and be sued in contract, correct?
Yes.
And if the government can be sued, and that is a right given in our Organic Act, which is our de facto constitution, can the legislature enact a law that takes away that right or that prevents the government being sued on contract?
Well, I think initially you have to understand that, consider that WAPA is a public corporation. So
regardless, it says that the government can be sued and be sued. So
Sure.
if the government can, certainly its public instrumentalities can. And if they can be sued and be sued, and the definition of what it is to sue includes not only the right to begin and continue an action, but to also see it through to the end and collect on it. If the Organic Act specifies that the government may be sued in contract, can the legislature pass a law that directly conflicts with that section?
my answer to that is I don't think that it conflicts. I think it's fully possible.
But tell me how it doesn't conflict. If you have a right that's granted in your constitution, in your organic document, that says the government can be sued, and the definition of being sued is to commence or continue an action and to continue it to conclusion, including collecting the benefits of the contract. So if the legislature pass a law, whether it's only to WAPA, whether it's to whoever, that says you can't collect ever, doesn't that basically just render the contract nothing more than a request for payment? And if you don't get it, you can't do anything about it?
Not when you consider, no, not when you consider the difference between private corporations and public corporations. So, for example, let's go.
But the Organic Act makes no exceptions. It simply says you have that parties have a right to sue. It simply, the Organic Act, strike that, simply indicates that there is a right to sue and to be sued in contract. And it makes no exception. So why would that language accept municipal corporations or government corporations or municipal, any kind of corporations or public utilities?
The legislature is permitted to pass legislation within this purview, which would be the time, place, and manner of enforcement of judgments. That is true, based off of the full faith and credit clause. And so they are permitted.
But doesn't it says that they have the right of all legislative actions not inconsistent with the laws of the United States, or the laws made applicable to the Virgin Islands? And if you have the Organic Act, which is certainly applicable to the Virgin Islands, that says you can sue the government, but can the legislature then basically pass a law that makes that right a nullity by saying you can't ever collect? And the fact that WAPA is, and I grant you, it's the only utility in the territory, and the government has a right to do it, but can it do it by nullifying a provision that is in your Constitution and your, and the Organic Act?
I don't view it as a nullification of the rights as a government.
It's not?
Government to be sued.
So if you can sue on contract, but you can't collect ever on that contract, isn't that, you're getting part of it. You can get a judgment, but then you can't ever collect that judgment. Is that?
The lower court and the U.S. Supreme Court acknowledges this, right? This idea of having an obligation and having a right.
I understand. That's under the contract clause, but now we are dealing under this right to sue and be sued, which is separately and totally different from the contract clause. The contract clause basically will prevent legislation that interferes with a contract. In this case, the legislation existed years before this contract, so I don't see how this would ever be, the contract clause would ever be even applicable to this.
Okay.
But I'm dealing with the other provision that says the government can be sued, can sue in its name and be sued, and that doesn't say it can sue, but you can't ever collect against. I just want to know how can you legislate away a constitutional right?
The legislature, in my opinion, based off of the case law, hasn't effectively legislated away the constitutional right, because while you can sue WIWAPA and you can obtain,
you say all of the cases dealt with tort actions, which they have an absolute immunity to. They didn't have to waive immunity at all. They could have exercised their absolute immunity, but that's not tort. You see, that's the second one when it says with the contract. Matter of fact, the government of the Virgin Islands shall have the right to sue by such name and in cases arising from contract be sued, provided that no tort action shall be brought against the government of the Virgin Islands or against any officer or employee thereof in his official capacity without the consent of the legislature. So we're not talking with the tort portion of it. We're simply talking about the contract, which is unconditional, other than for tort.
Well, in practice, there can be voluntary payments made by WIWAPA. There could be insurance that could cover it, the contract, the issue of the contractual obligations. And I see this exemption.
Does WIWAPA have insurance that will cover a contract?
To the best of my knowledge, no, but it could have insurance that covers. But to the best of my knowledge, I'm not aware, I should say. But I think the point is, and I think we're getting off of this concept of why in the common law there's a protection given to public corporations existing for a public purpose. The assets of WIWAPA.
You can't go with the common law. You have the Organic Act, and that's that's your founding document. You can't, the common law can't contradict that. Just like you can't alter the Constitution by some common law, right? So, well,
I recognize what the Revised Organic Act states. And our position is simply that.
But you have never even, at least no one in the briefs even addressed this issue, correct?
I didn't address the issue in the briefing. No, I did not, because I already had argued that the constitutional arguments were waived, and then I went on to argue about Concepcion and Turbe in response to the appellant's briefing. But I did review it on my own, the Revised Organic Act provision, to understand the difference between what would it mean to sue a municipal corporation, which would be the state, and what would it mean to sue a public corporation like WIWAPA. And so that's where my train of thought went, because the assets of WIWAPA are so vital and so important, WIWAPA, Waste Management, Port Authority, that if you were able to attach to those funds, the consequences would be catastrophic. Right? If you're able to attach to the personal property, that being in a bank account, then we can't pay for the generators, we can't pay for fuel. It is a slippery slope and it's a dangerous result. A lot of times West Indian people say without wisdom our people will perish. 30 VIC section 111A represents that wisdom, a vision to recognize that in the face of a pandemic, in the face of fuel costs, in the face of war, the assets of WIWAPA will remain protected. Assets of all of our public corporations, because we cannot afford for it not to exist. So I don't see it as conflicting with the Revised Organic Act. You can sue and be sued, Attorney,
Attorney,
Yeah,
let me ask you a question. Should, despite what the Organic Act says, despite what all the laws might say, are you suggesting that there's a public policy here that the health and welfare of the community would take precedent over what would happen if people are allowed to, other than the bondholders, because the bondholders have a preferred status, that what would happen if people start suing WIWAPA, getting judgments, go down to the plants, start confiscating his bank account, can't pay his employees, take over the plant, start selling it off, and whatnot? What would happen to our hospitals, schools, police department, fire department, the people in general of the Virgin Islands? Should that be considered in terms of a public policy, since WIWAPA is the only party that could provide the electrical grid that we now have in St. John and St. Croix and St. Thomas?
yeah,
What
absolutely.
would happen to the people of the Virgin Islands and the South? Should that be a consideration? Taking into consideration that this law that exempt WIWAPA from 111A, that has been around since either the 1960s or 1970s, because I noticed at the top that there was a Concepcion versus Soto going back to 1975 by the Third Circuit, in which it says that that as the WIWAPA can refuse to pay judgment entered against it, and there is a public policy why the statute was enacted in order to protect WIWAPA and to protect the community. We can't divorce WIWAPA from the community.
We can't,
So
because
we have to consider that in light of everything else.
Absolutely, and I still hold firm to the belief that it does not violate the Revised Organic Act. That's just my position, because you have to consider the difference. Even if it's not explicit, it should be considered implicitly that public corporation can be treated differently. It's the reason why we are autonomous and that we are not tied completely to the government. These are two separate entities. And
what can be done?
I thought I agree.
WIWAPA pays,
I've gone way too far.
its bills.
All right, we kind of gone over. So
Yeah.
I just want you to know, this is strictly with the contracts. You know, this is the contracts that WIWAPA enter into. And should they be allowed to enter into any kind of contract and simply don't even appear to defend them in court and simply say, well, you can't collect? And that's too bad. In this case, WIWAPA did not appear to defend in Minnesota. It didn't appear to defend the petition to domesticate, and simply can just stay back and say, well, there's nothing you can do. You can't collect against me. Is that the public policy that WIWAPA really wants to represent? I mean, who will ever contract with WIWAPA if that's the position?
Well, I can assure you that that's not a concern. We're still getting regular contracts. So that's a practical sense. But I don't believe, especially with our new leadership, that is our position. It's not our position to avoid it. I can't speak for what previous council had done and why there wasn't representation in Minnesota or even here in the Virgin Islands. But you read my reply in my motion to quash, well-researched, explaining Concepcion and Turbay. This isn't a case of running away.
Those cases don't really apply to this. This is a contract, and this is, we're talking about the right to sue and be sued on contracts as opposed to torts. And
well, the statute
is there any way that is there an argument from you that somehow this provision is on the books? It should almost be implied and incorporated in every contract that WIWAPA enters into. And if somehow someone is in Minnesota and doesn't know the VI law, that they should be bound by the law that's on the books. I mean, that's the only way I can see.
Absolutely, I think that
would be to include this, at least include reference to it in every contract, so that at least people will be on notice. And and then maybe, but since we've gone over, let's just allow Attorney Ben. Yes, you have a question?
I have no question. I have a request. We need a technology break before everything goes black over here.
Okay.
All right.
We'll take a 5-minute break, and then we'll come back to you, Attorney Ben, for your 3 minutes.
Thank you.
5 minutes, Chief. Chief, 5 minutes.
5 minutes, yeah.
Yeah, because I didn't want to interrupt, but I have had a lot of difficulty since the WAPA case begins, hearing people and understanding what is being said, and that's why I don't want to ask any question, because I just can't understand.
Okay.
Mine seem to be gobbled a little.
Yeah, well, hopefully it'll be 5 minutes, so let's just take a break and we'll be back.
In 5. All right, okay,
5.
Chief. Good.
Thank you, Your Honor. First of all, in response to the question you asked me earlier, the Revised Organic Act incorporates the Federal Contracts Clause, specifically providing that no law impairing the obligation of contract shall be entered. That's Revised Organic Act 1954, Section 3, Clause 6, codified at 48 U.S.C. 1561. So that's where it is. Also, Your Honor.
What? It says what?
No law impairing the obligation of contract shall be enacted.
Right, but that's the Organic Act provision. I'm just simply saying that the constitutional provision is not applicable to the Virgin Islands.
They use the same language. There is a WICO case, Your Honor, WICO Limited versus the Governor of the VI, 844 Fed 2nd, 1007.
Right, I'm familiar with that, and I know what it says, and
okay.
It doesn't give any reason. It simply says that it's applicable, but
well,
that doesn't.
Okay, I understand your point, Your Honor. I hope you understand mine. The language is the same, and I don't think the legislature of the Virgin Islands can make a law impairing the obligation of contracts. It's an very
in this case, how does the contract clause interferes with your case, where you have the law has been in effect long before your contract? It has to be that there's a contract and then a law comes into being that impairs that contract, and that is not the situation here. So how would that provision of the Revised Organic Act?
I don't think that's the case, Your Honor. The plain reading of that statute is that the legislature cannot make a law that impairs the contracts. It doesn't put
right,
any.
But that's what I'm saying. You didn't have a contract that a law was passed that impaired it. It doesn't say that no law, can ever be in the thing that somehow adversely affects the contract.
But you understand that WAPA was created at the same time as this statute, so no contract existed that could have been challenged ever. So if the law is either constitutional or it's unconstitutional, it has to be challenged.
No, but I think you're missing the contract as applied to you. Your client entered into a contract long after that law was in place. So that law could not have impaired your contract because it didn't exist at the time. But, I understand your position.
Yeah, the position is that that the contract came after the legislation, but it's impossible for any contract to come before the legislation. And
well, then that's why the contract clause wouldn't be applicable. If you've looked at any application of it, it can't impair a contract when it was in place long before the contract.
Right, and the interpretation of the Superior Court in this case does impair the client's contract. Also, to Justice Swan's point earlier, the consequences of paying its debts is not catastrophic. Murphy's not asking for a huge judgment. They are only asking for monies that they were promised and that they have a default judgment for. The other point, Your Honor, is that it would be.
I think Justice one question is that not necessarily your case. Your case may be a small judgment, but the statute is there to protect the assets. Yeah.
Right, but I agree that the public policy is in favor of protecting WAPA's assets. I understand that, but the people of Virgin Islands, from huge judgment. But payments of the contract is totally different. It's not an unexpected and should have been budgeted for. Also, with regard to the illegality.
I would think that every contract they entered into would be budgeted for. But, you know, that's not the way
they're
things work in real life.
They're using this as an escape clause. It's like, okay, you can run around, run up your credit card, and then go bankrupt. You know, I mean, that's basically the public policy that's being espoused here.
The law was on the books, and you still entered into a contract with them. So, you know, what does that say about you?
Well, I wasn't there.
If you don't want to be subject to the laws that apply to WIWAPA, then you don't contract with them.
But Murphy not having knowledge of the uncollectability, they asked specifically to have sovereign immunity waived.
So, when has ignorance of the law been an excuse?
It doesn't make it constitutional, Your Honor. Nothing makes it constitutional. Also, with regard to the illegality of the petition that you raised earlier, Your Honor, I believe that Judge Dunstan raised that issue and found that it was valid, and that WIWAPA has raised that argument.
Which one are you talking about?
About the issue of the original petition being filed. They've waived it. They never raised it in opposition to in their motion to quash. And Judge Dunstan entered the petition despite the footnote. So I think that WIWAPA has raised that, aside from the fact that, and I believe you talked about that, Your Honor. But it's the policy behind a public entity having to pay their debts is throughout the Supreme Court case law. And it doesn't say that it has to be, the contract necessarily has to be existing at the time the law is passed. I believe I'm past my time, Your Honor.
All right, thank you. The matter will be submitted.